Hi, my name is Nils O'Donoghue. I'm one of the partners here at Chadwick Lawrence. Although it's quite deep into January already and time is flying by, this is my first video of the year, so I hope everyone had a restful and productive festive break and a happy new year. I have come across a series of interesting cases since we came back from the New Year break, and also at the back end of last year, where COVID is still having an effect on businesses and is actually ending up with some clients of mine appearing in court. And indeed there's been a number of other well publicised cases whereby the effect of home working and furlough continues to have an impact on businesses, and in the cases I've been dealing with has actually led to certain businesses appearing in court. For example, it may be that you have a fleet of vehicles, and as a result of an individual being caught speeding by either a handheld or fixed camera, you might be familiar with the requirement to identify a driver. For those of you who are not familiar, when a vehicle is caught speeding, the police will routinely send out a notice asking the register keeper of that vehicle to identify the driver. What I'm finding is that there are certain businesses who were shut completely or partially during lockdown, and as a result haven't been dealing with their post in the same manner that they normally would, and therefore haven't been identifying drivers of vehicles. Sadly, this is landing those businesses in court for failing to identify the driver of a vehicle which is suspected of speeding. There's also been a fairly well reported case where an employer has challenged the fact that they didn't pay their data protection fee. They were a business that processes personal data, as your business may be, and were required to pay the appropriate yearly fee to the Information Commissioner. They didn't pay that fee and said that was because the reminder letters that they got weren't opened as a result of their employees being on furlough. What I'm finding is that the courts are taking a fairly brutal attitude to these types of arguments. It's really important, therefore, that if you are having a hybrid working situation or are now entirely working from home, that your post is still dealt with promptly. So, for example, if you do get a notice requiring you to identify a driver, that you open that, review it, identify the driver and return it in a timely fashion. My experience at the moment is that courts are simply not allowing employers, businesses to say we couldn't respond to such notices as a notice requiring you to identify the driver, or a data protection fee letter, reminder letter, because of COVID. They are still expecting that there's a certain level of business continuity and planning that needs to be put in place, and that you discharge your duties. So an important reminder, as simple as it may seem, to remember to deal with your post and any important legal letters that you receive from the police or any other regulator. And there's also been some announcements by HMRC and a fairly large case that took place in December, which is of interest to those of you who might be covered and indeed have measures in place to prevent money laundering. HMRC has published it's businesses that have not complied with the anti-money laundering regulations, and it serves as a timely reminder that if you are a business that may be susceptible to money laundering, that you have proper policies and procedures in place which we can assist you with should you need to. Not only has HMRC published a register of businesses that haven't complied with those regulations, but there's been an extremely high profile case involving NatWest, whereby over £400 million worth of criminal money was laundered through NatWest's banking system. NatWest pleaded guilty to the offence of failing to comply with the anti-money laundering regulations. They still received an extraordinary large fine of £264 million. As I say, NatWest pleaded guilty to this offence. Had they not done so, the fine would actually have been £397 million. While this case is obviously the exception rather than the rule, it is important that if you are a business that's required to comply with the anti-money laundering regulations, that you do so to avoid not only any such fine, but the unwanted publicity and distress of being involved with such a case. Finally, an update from the government this week, which was that the Justice Secretary has announced plans to increase the Magistrates' Court sentencing power to 12 months imprisonment for a single offence. The Magistrates' Courts, as we know well here at Chadwick Lawrence, are dealing with a huge backlog and hopefully if you are one of our clients who's involved with a magistrates court case and is waiting for a date, this process may be speeded up should these plans come into effect in the coming months. It is interesting, however, that the government appears to be blaming COVID for such a backlog of cases, when unfortunately the reality is that the court system has been underfunded for many years, but hopefully this is a step in the right direction to decreasing waiting times for those who are going through the stressful experience of waiting for attendance in the magistrates court. I hope this has been helpful and informative. As always, if you do have any questions, please do contact either myself or one of my colleagues here at Chadwick Lawrence. Thank you.